On yesterday ordered the city to count the citizens' signatures that have been advanced to exercise the charter proviso, which allows citizens to exercise their power in a referendum initiative, in a referendum context or an initiative context. And given what the Texas Supreme Court has said on Friday, plus what in my view is pretty plain in the charter, I think the city is doing the same thing again on yesterday that we did back in August again. And I'm going to ask the city attorney's office to please articulate to the Houston City Council at some point, because the Texas Supreme Court gave a pretty good admonishment to the Houston City Council, indicating that Houston City Council did not fulfill its charter duty. And I want to make sure that the city attorney's office explains to City Council how it will interpret the charter prescription as it relates to referendum and initiative type petitions. It's pretty clear reading the charter, and it's spelled out in the Supreme Court's ruling last Friday that if in fact a referendum or initiative type petition is presented, it is to be presented to the city secretary. And the city secretary entertains that request with consultation with whomever she wants to consult, whomever. But at the end of the day, the city secretary gets to make the decision. And I don't get to intervene in that process. The mayor doesn't get to intervene. The city attorney doesn't get to intervene. We don't get to intervene in that process. The city secretary's charged with duties. What it seems to me that the petition signature that was presented by a citizen about 2 weeks ago, whether they were proper or not, it seems to me that the Texas Supreme Court has said, and the charter indicates, that the city secretary gets to entertain that particular submission. But on yesterday, the city filed an appeal to the judge's ruling, which is pretty consistent with what the Texas Supreme Court has said in the other case. So I'm just concerned about the interpretation that the city is taking as it relates to what the charter says on its face. And secondarily, I'm really getting concerned about the cost now, because the other side, they're going to sue for attorney fees, I suppose, and they'll probably prevail for attorney fees, and some of them are saying that's in the area of $500,000 now. That's in the litigation that the Texas Supreme Court issued a mandamus on Friday. On yesterday, it's a separate cause of action that we are appealing again, accruing attorney's fees on the other side again. And it seems that this will go back to the Texas Supreme Court at some point. And I have no reason to believe that the Texas Supreme Court is going to rule any differently in this particular situation. So whether one agrees or disagrees with the substantive item in chief, that's not the point. The point is, who makes the decision whether a referendum effort or an initiative effort goes to the voters or not? At some point, the charter says City Council gets involved after the city secretary makes a decision. And council has not had that opportunity, and that's why when you read the Texas Supreme Court's opinion, it really speaks as to what is indicated in the charter. The Texas Supreme Court, in my view, correctly articulates the charter requirement as to what council is supposed to do, and that's not happening in the city of Houston. So at some point, I'm going to ask the city attorney's office to very formally outline when the city attorney's office, when the mayor is permitted to engage or involve in that process, when the charter articulates the duties specifically and exclusively to the city secretary. And I'll reiterate again what the court said. Certainly the city secretary can consult anyone that they deem necessary. The charter is pretty clear on this point. Thank you.